Yes, my lord. Yes, my lord. The first Chief Minister of Kerala, P.M.S. was convicted for contempt of court. And that was for expressing a grievance of the common man. Recently, the President of the United States, Trump, was convicted for contempt of court. The difference was, the earlier was for speaking for the cause of the common man. Trump was convicted for intimidating witness, my lord, interfering with the administration of justice. My stand is, my lord, that the dignity of the court as an instrument of doing justice, if for that purpose contempt of court is required, yes, I am for that. But that has to be construed very liberally, and the institution of judiciary, being allowed in a democratic state, is no longer the king's court. It is a court, is a power, is a trust accountable to the king. This is not my. I am not completely asking for abolition of Contempt of Courts Act. That jurisprudence certainly may be required for enforcement of what is. But that is a very narrow area. What that I am against the contempt of court, even today, which is, my lord, even in this country, which is in the realm of star chambers. My lord,
We can hear the respondents now.
Yes.
So, because otherwise this is a special bench, we do not assemble every day. That is Union of India?
Yes, beautifully. My submission to the relief sought in the petition, first of which states, declare that Contempt of Courts Act 1971, sections 2C1, 14, 16 and 17(5) are unconstitutional. And the second relief is to the effect that, my lord, section 16 of the Contempt of Courts Act be made applicable to judges of higher judiciary as well. Now, my lord, section 129 of the Constitution of India provides that the Supreme Court shall be a court of record and shall have all the powers. Such a court, including the powers to punish for contempt of itself. Article 215 is the corresponding provision which enables the High Court to punish for contempt. Now, my lord, as far as the Contempt of Court Act 1971 is concerned, it was subject to several judicial scrutinies with respect to its applicability and also its powers restricting right to free speech and also other freedoms enshrined under Article 19 of the Constitution.
Yes.
Now, my lord, subsequent to the Law Commission report, the 200th Law Commission report, my lord, which was specifically designed to verify whether the Contempt of Courts Act provisions restrict freedom of free speech and also that of media, has given a detailed report. And based on that, my lord, the National Commission to Review the Working of Constitution has also examined and considered the law of contempt and made recommendations for amendments in Article 19(2) and Article 29 of the Constitution. Accordingly, my lord, based on the recommendations by the National Law Commission and also by the Commission to Review the Working of Constitution, my lord, the Act has been amended and to permit a defense of justification by truth. Lords may kindly have a look at section 13 of the Contempt of Court Act as it stands now. May I read, my lord? The Lord's permission. May I read?
Yes.
Notwithstanding anything contained in now for the time being in force, no court shall impose a sentence under this act for a contempt of court unless it is satisfied that the contempt is of such nature that it substantially interferes or tends substantially to interfere with the due course of justice. The court may permit in any proceedings for contempt of court justification by truth as a valid defense if it is satisfied that it is in public interest and the request for invoking the said defense is bona fide. So, my lord, it is very explicit from the wording of the statute itself that
Yes.
from the very wording of the statute itself, my lord, it doesn't curtail any kind of right to expression of any individual, as the case may be. For in any case, because he is given a right under the statute itself to justify his words, speeches, or conduct under the context of justification by truth. So the apprehensions are unfounded, my lord. Now, my lord, Article 19(2) itself permits reasonable restrictions to freedom of speech and expression. So, my lord, anybody cannot claim to make any kind of expression which is permitted beyond the restrictions of Article 19(2).
Yes.
Now, my lord, the grievance with respect to section 2C1, 14, and it's 17(5), my lord. What may kindly see that section 23 of the Act empowers the Supreme Court and High Courts to formulate rules governing the proceedings, ensuring procedural safeguards and due process. What may kindly see that the Contempt of Court Act is not a substantive law and it doesn't create anything new which was not in existence at the time of enactment of this law. It is purely a procedural law, as your lordship will find from the preamble of the statute itself. May I read the preamble?
Yes.
An act to define and limit the powers of certain courts in punishing contempt of court and to regulate their procedure in relation thereto. So, my lord, essentially, my lord, the object of the act is to create a procedure in order to regulate the process of punishment for contempt by the court. And section 23, my lord, your lordship will find the Supreme Court, or as the case may be, any High Court, may make rules not inconsistent with the provisions of this Act, providing for any matter relating to this procedure. And the procedure has already been provided in section 11 to 14, sorry, my lord, 15 of the Act. So this is a statutory given provision for the which is for the High Courts and also the Supreme Court to punish for contempt. This has been upheld in several decisions of various forums, my lord, right from 1954 onwards. The first of, may I pass over the first? In Hiralal Dikshit's case, my lord, the first of its kind, 1954 Supreme Court 325, my lord. will find para 6 and 8 of the judgment are relevant. May I read paragraph 8, maybe? This was well established as was said by this court in Brahma Prakash Sharma's case, that it is not necessary that there should in fact be an actual interference with courts of administration of justice, but that it is enough if the offending publication is likely or if it tends in any way to interfere with the proper administration of law. Such insinuations as are implicit on the passage in question are derogatory to the dignity of the court and are calculated to undermine the confidence of the people in the integrity of the judges. Whether the passage is read as fulsome flattery of the judges of this court or is read as containing the insinuations mentioned above, or the rest of the leaflet which contains an attack on a party to the pending proceedings is taken separately, it is equally contemptuous of the court in that the object of writing it and the time and place of its publication were calculated to deflect the court from performing its strict duty, either by flattery or by a vague threat or warning or by creating prejudice in its mind against the state. Now, paragraph 9, my lord. It should no doubt be constantly borne in mind that the summary jurisdiction exercised by the Supreme Court in punishing contempt of their authority exists for the purpose of preventing interference with the courts of justice and for maintaining the authority of law as is administered in the court, and thereby affording protection to public interest and in the purity of administration of justice. This is certainly an extraordinary power which must be sparingly exercised, but where the public interest demands it, the court will not shrink from exercising it and imposing punishment even by way of imprisonment in cases where a mere fine may not be adequate. And paragraph 10 also, my lord, which is the conclusion. In fit case where the power of the court should be exercised and that it is necessary to impose the punishment of imprisonment, people must know that they cannot with impunity hinder or obstruct or attempt to hinder or obstruct the due course of administration of justice. Same course was followed in 2002-3 Supreme Court 343 within Arundhati Roy's case, my lord. In a suo motu proceedings, my lord, the Supreme Court has
Yes.
my lord, there at paragraph 31, my lord. 31 to 34 are relevant with respect to the fact of the case, and paragraph 30 is the observation, my lord. The Constitution of India has guaranteed freedom of speech and expression to every citizen as a fundamental right. While guaranteeing such a freedom, it has also provided under Article 129 that the Supreme Court shall be a court of record and shall have all the powers of such a court, including the power to punish for contempt itself. Similar power has been conferred on the high courts of the states under Article 215. Under the Constitution, there is no separate guarantee of the freedom of press, and it is same freedom of expression which is conferred on all citizens under Article 19(1). Any expression of opinion would therefore be not immune from the liability for exceeding the limits, either under the law of defamation or contempt of court or the other constitutional limitations under Article 19(2). If a citizen, therefore, in the grab of exercising right of free expression under Article 19(1) tries to scandalize the court or undermines the dignity of the court, then the court would be entitled to exercise powers under Article 129 or Article 215, as the case may be, in relation to a pending proceedings before the court, while showing cause to the notices issued when it is stated that the court displays a disturbing willingness to issue notice on an absurd, despicable, entirely unsubstantiated petition. It amounts to destructive attack on the reputation and credibility of the institution, and it undermines the public confidence in the judiciary as a whole, and by no stretch of imagination can be held to be a fair criticism of the court's proceedings. When a scurrilous attack is made in relation to a pending proceedings, and the noticee states that the issuance of notice to show cause was intended to silence criticism and muzzle dissent, to harass and intimidate those who disagree with it, is a direct attack on the institution itself, rather than the conduct of an individual judge. The meaning of the expression used cannot come within the extended concept of fair criticism or expression of opinion, particularly to the case of the contender in the present case, who in her own right is an acclaimed writer in English. Now, my lord, there also, my lord, the dictum examines to what extent, my lord, the power of contempt can be exercised by the court before finding the accused guilty of contempt.
Which para?
There will be what we have referred to in paragraph 30, my lord. 30 is the relevant portion with respect to
No, that we
which I have read. Actually, I was adding. My lord, now in Prashant Bhushan case, my lord, 2021 1 Supreme Court 745. Paragraph 43 to 49 are relevant, my lord. Paragraph 45. Onwards.
Yes.
What then are the complex of considerations decisive of connective action? To be exhaustive is a baffling project. To be pontifical, to be impractical, to be flexible is to be realistic. What then are these broad guidelines? Not a complete inventory, but precedentially validated judicial norm. The first rule in this branch of contempt power is a wise economy of use by the court in this branch of jurisdiction, the court will act with seriousness and severity where justice is jeopardized by a gross and or unfounded attack on the judges, where the attack is calculated or obstruct or destroy the judicial process. The court is willing to ignore by a majestic liberalism, trifling and venial offences. The dogs may bark, the caravan will pass. The court will not be prompted to act as a result of an easy irritability. Much rather, it shall take a neotic look at the concepts of features and be guided by a constellation of constitutional and other considerations when it chooses to use or desist from using its power of contempt. The second principle must be to harmonize the constitutional values of free criticism, the fourth estate included, and the need for a fearless crucial process and its presiding functionary, the judge. A happy balance has to be struck, the benefit of the doubt being given generously against the judge, slurring over marginal deviations, but severely proving the supremacy of the law over punctilious, vicious, unrepentant, and malignant contemners, be they the powerful press, gang up of vested interest, veteran columnists of Olympian establishmentarians, not because the judge, the human symbol of a high value, is personally armored by a real privilege, but because be you the contemner, ever so high, the law, the people's expression of justice is above you. Crucial courage overpowers arrogant might, even as judicial dignity forgives errant or exaggerated critics. Indeed, to criticize the judge fairly, albeit fiercely, is no crime, but a necessary right twice blessed in a democracy. For it blessed him that gives and him that takes, where freedom of expression fairly exercised subserves public interest in reasonable measure. Public justice cannot gag it or manacle it. Constitutionally speaking, a free people are the ultimate guarantors of fearless justice. Such is the cornerstone of our constitution. Such is the touchstone of our contempt power, oriented on confluence of free speech and fair justice, which is the scriptural essence of our fundamental law. Speaking of the social philosophy and philosophy of law in an integrated manner as applicable to contempt of court, there is no conceptual polarity but a delicate balance, and judicial sapience draws the line. As it happens, our constitution makers foresaw the need for balancing all these competing interests. Section 2C of the Contempt of Courts Act 1971 provides criminal contempt means the publication, whether by word, spoken or written, or by signs or by visible representations or otherwise, of any manner or the doing of any other act whatsoever which scandalizes or tends to scandalize or lowers or tends to lower the authority of any court. This is an extremely wide definition, but it cannot be read apart from the concepts of the constitutional provisions within which the founding fathers of the Constitution intended all past and future statutes to have meaning. All laws relating to the contempt of court had, according to the provisions of the Article 19(2), to be reasonable restrictions on the exercise of right of free speech. The courts were given the power and indeed the responsibility to harmonize conflicting aims, interests and values. This is in stark contrast to the Fillmore Committee report on contempt of court in the United Kingdom, which did not recommend the defense of the public interest in contempt case. The third principle is to avoid confusion between personal protection of a liable judge and the prevention of obstruction of public justice and the community's confidence in that great process. The former is not contempt, the latter is, although overlapping spaces above. Because the law of contempt exists to protect public confidence in the administration of justice, the offense will not be committed by attack upon the personal reputation of individual judges as such. As Professor Goodhart has put it, scandalizing the court means any hostile criticism of the judge as a judge, any personal attack upon him, unconnected with the office he holds, is dealt with under the ordinary rules of slander and libel. Similarly, Griffith CJ has said in the Australian case of Nicholas that, in one sense, no doubt, every defamatory publication concerning a judge may be said to bring him to contempt, as that term is used in the law of libel, but it does not follow that everything said of a judge calculated to bring him into contempt in that sense amount to contempt of court. Thus, in special reference from the Bahama Islands, the Privy Council advised that a contempt had not been committed through a publication in the Nassau Guardian concerning the resident Chief Justice, who had himself previously criticized local sanitary conditions. Though couched in highly sarcastic terms, the publication did not refer to the Chief Justice in his official as opposed to personal capacity. Thus, while it might have been a libel, it was not a contempt. The fourth functional canon, which channels discretionary exercise of the contempt power, is that the fourth estate, which is an indispensable intermediary between the state and the people, and necessary instrumentality in strengthening the forces of democracy, should be given free play within responsible limits, even when the focus of its critical attention is court, including the highest court. The fifth normative guideline for the judges to observe this in this jurisdiction is not to be hypersensitive when even where distortions and criticisms oversteps the limits, but to deflate vulgar denunciations by dignified bearing, condescending indifferent and repudiation by judicial rectitude. The sixth consideration is that after evaluating the totality of factors, the court considers the attack on the judge or judge's serious, offensive, intimidatory, or malicious beyond condemnable limit. The strong arm of the law must, in the name of public interest and public justice, strike a blow on him who challenges the supremacy of the rule of law by following its rules and state. So, my lord, after referring to the 5 principles which the court should follow, the court has in this case also examined whether the act purportedly done by the accused was interfering into the administration of justice and intimidating the process of law, and has proceeded to punish the accused. This has been followed in a series of other cases as well, my lord. In Dr. D.C. Saxena versus Chief Justice of India, 1996, 5 Supreme Court cases, 216, my lord. This has also followed the same principles, my lord. Should I read it? Paragraph 29 to 31 is relevant, my lord, along with paragraph 57. May I read with paragraph 29. 28. The question therefore arises whether the aforementioned imputations constitute contempt of court. Though the petitioner contended that the provisions of the Act are ultra-virus, Article 19(1)(a) of the Constitution, it is not necessary for the purpose of this case to dwell upon that contention. The court has taken suo motu cognizance of contempt of this code under Article 129 of the Constitution of India, which reiterates as a court of record its power to punish for contempt of itself. As pointed out in the proceedings of this court dated 13/1/1996, in spite of the fact that this court brought to his attention the gravity of the imputations, the petitioner insisted and reiterated that he stood by the scandalous averments made therein. The court, being duty bound, was therefore constrained to issue notice of contempt. The question therefore is whether the aforesaid imputations are serious attack intended to scandalize the court, and do they not impede due administration of justice? Words are the skin of the language. Language in which the words are couched is media to convey the thoughts of the author. Its effect would be discernible from the language couched proprio vigere. The petitioner, a professor of English language, in clear and unequivocal language, emphasized and reaffirmed that the affirmance were truthfully and carefully worded. The question is to what extent the petitioner is entitled to the freedom of those expressions guaranteed under Article 19(1)(a) of the Constitution. If they are found scandalous, whether he would get absolved by operation of Article 19(1)(a). As this court has taken suo motu action under Article 129 of the Constitution and the word contempt has not been defined by making rules, it would be enough to fall back upon the definition of criminal contempt defined under Section 2C of the Act, which reads thus: criminal contempt means publication, whether by words spoken or written, or by signs, or by visible representations, or otherwise, of any matter of the doing of any other act whatsoever which scandalizes or tends to scandalize, or lowers or tends to lower the authority of any court, or prejudices or interferes or tends to interfere with the due course of any judicial proceedings, or interferes or tends to interfere with, or obstruct the administration of justice in any other manner. It's doubtless that freedom of speech and expression guaranteed by Article 19(1)(a) is one of the most precious liberties in our secular socialist republic. Freedom of expression is a prized privilege to speak one's open mind, although not always in perfect good taste of all institutions, since it opens up channels of open discussion. The opportunity of speech and expression should be afforded for vigorous advocacy, not less than abstract discussion. This liberty may be regarded as an autonomous and fundamental good, and its value gets support from the need to develop our evolving society from unequivocal past to a vigorous, homogeneous, egalitarian order, in which each gets equality of status and of opportunity, social, economic, and political justice with dignity of person, so as to build an integrated and united Bharat. Transformation for that strong social restructure would be segued when channels for free discussions are wide open and secular modes are not frozen. All truths are relative and they can be judged only in the competition of market. Liberty is not to be equated with certainty. Freedom of expression equally generates and disseminates ideas and opinions, informations of political and social importance in a free marketplace for peaceful social transformation under the rule of law. The doctrine of discovery of truth does not require free exchange of ideas and use of appropriate language. Does require. I'm corrected. Words are the skin of the language which manifests the intention of its maker or the speaker. The right to free speech is therefore an integral aspect of right to self-development and fulfillment of persons' duties, some of which are postulated in part of in Part 4A of the Constitution as fundamental duties. The end of the state is to secure the citizen freedom to develop his faculties, freedom to think as he will, to speak as he thinks, and reads an indispensable tool to the discovery of truth and realization of human knowledge and human rights. Public discussion is political liberty. The purpose of freedom of speech is to understand political issues so as to protect the citizens and to enable them to participate effectively in the working of the democracy in a representative form of government. Freedom of expression would play a crucial role in the formation of public opinion on social, political, and economic questions. Therefore, the political speeches are given greater degree of protection and special and higher status than other types of speeches and expression. The importance of speakers' potential developing and political and social questions is also relevant to encourage human development for effective functioning of democratic institutions. Equally, the debate on public issues would be uninhibited, robust, and wide open. It may well include vehement, sarcastic, and sometimes unpleasant, sharp criticism of government and public officials. Absence of restraint in this area encourages a well-informed and politically sophisticated electoral debate to confirm the government in tune with the constitutional mandate to return a political party to power. Prohibition of freedom of speeches and expression on public issues, prevents and stifles the debate on social, political, and economic questions, which in the long term endangers the stability of the community and maximizes the souls and breeds for more like revolution. And paragraph 32, my lord. The freedom of speech and expression therefore should be subject to Articles 19(2), 129 and 215 of the Constitution in relation to contempt of court, defamation or incitement to an offence, etc. Article 3 read with Article 19 of the Universal Declaration of Human Rights grants to everyone liberty and right to freedom of opinion and expression. Article 19 of the International Covenant on Civil and Political Rights 1966, to which India is a signatory, had ratified, provides that everyone shall have the right to freedom of expression, to receive and impart information and ideas of all kinds. But Clause 3 thereof imposes corresponding duty on the exercise of the right and responsibilities. It may therefore be subject to certain restrictions, but these shall only be such as are provided by law and are necessary for the respect of life and reputation of others, for the protection of national security or public order or of public health or morale. It would thus be seen that liberty of speech and expression guaranteed by Article 19(1)(a) brings within its ambit the corresponding duty and responsibility and puts limitation on the exercise of that liberty. Goes on narrating the restrictions that are faced.
Yes.
It goes on to define, my lord, the restrictions that are placed on freedom of speech and expressions, cautioning upon those who are making the expressions to be very cautious while and to be duty bound while making their own expressions. It is one of the apprehensions faced by the petitioner. Now, my lord, 1971, one Supreme Court, CC 620. Party CK dark 3 under this. CK dark. This judgment also, my lord, in paragraph 48, 51 and 52, my lord, referring to various other judgments, my lord, defines reasonable restrictions on the context of Contempt of Courts Act, my lord. Paragraph 48. And 48. 47 refers to facts of the matter. Relying on these authorities, Mr. Daftria urges that at the time when Constitution was enacted, it was well known what the powers of a superior court of record were in England and what was the law of contempt which the courts of record were administering, and therefore there should be no question of testing that law on the anvil of Article 19(1)(a) read with Article 19(2). It is not necessary to decide this point or the point whether the existing law relating to contempt of court is a law or not within the definition of the word law in Article 13(3)(a), as we have come to the conclusion that in any event the existing law imposes reasonable restrictions within the meaning of Article 19(2). Apart from this, the Constitution makes this court the guardian of fundamental rights conferred by Constitution, and it would not desire to enforce any law which imposes unreasonable restrictions on the precious right of freedom of speech and expression guaranteed by the Constitution.